I just want you to know, Your Honor, I'm here specially, not generally, and do so sui juris as the authorized agent for the family, Franthia family of the Price estate. So my appearance is strictly limited to the matter noted today, and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or implied legal disability or association with any bargain. I'm
Well,
here
I
as
get it, Miss Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So, if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
This is the point where confidence clashes with real authority. You'll hear phrases like, especially not generally, often used in fake legal arguments. But the judge responds calmly with one clear answer: constitutional jurisdiction. It perfectly shows the difference between dramatic performance and real courtroom procedure.
Your Honor, although like you, I'm a bit confused as to what the relief she's seeking here. I'm prepared to assert preferred's position legally here, and will wait for the court's direction as to when I can speak on that.
Very good. Well, let me go back to Ms. Price because it's her that initiated this motion appearance. What are you asking me to do at this time, Ms. Price, in a legal sense?
I respectfully request that the court take judicial notice pursuant to MRE 201B of the following two documents I previously filed into the court record. One is Exhibit J, OC 10, subpoena duces tecum, demand for custodial records. And number two, supplemental notice of clarification regarding the constructive subpoena duces tecum. These materials, Your Honor, are supported by the Federal Reserve Operating Circular number 10, Appendix 3, UCC Article 8, subsections 8, 102A, 14, and 15, 12 CFR, subsections 225 and 31 CFR, subsection 203, which
Let
collectively.
me just pause you just a minute, Ms. Price. The one thing I recognized of everything you said there was the Michigan Rules of Evidence and the term subpoena duces tecum, meaning you're directing a discovery subpoena. Is that directed at preferred credit?
It is, sir. I also wanted it to be on record because I previously asked for debt validation and didn't get anything in the lower court.
Okay.
Now we can clearly see the strategy. They're asking the court to take official notice of long, complicated legal references and to request records through a subpoena. But here's the truth: judicial notice isn't a quick way to reopen a case. Once a case is finished, you can't restart the process. Appeals review mistakes, not retry cases.
They're audits.
Your Honor, may I respond?
Yeah, go ahead, Mr. Mercutio.
Couple things, Your Honor. There's a lot to unpack there. Number one, we have a judgment in this case, so any attempt for discovery is outside, respectfully, the jurisdiction of this court at this point. I suspect what Ms. Price or the estate of Ms. Price or the Franthia Price family of Price estate is seeking to do here, Your Honor, is undo the judgment that was legally entered in the lower court case. So I would just say, Your Honor, what she's asking for is irrelevant and outside the bounds of what this court can do. The case is over as far as the district court is concerned. I can get into the argument as to the debt validation. I did produce with our response a motion for summary disposition there that did provide for the debt validation notice. Ms. Price continues to miss lower court and now this court that a debt validation was not given. It was in fact given. This is a simple credit card case, and she is trying to use I can't even characterize what these arguments are, Your Honor. I want to be respectful of Ms. Price's ability to defend this in pro per. But
I object, sir. I'm not in pro per. I'm sui juris. Thank you.
Okay, whatever that means, Your Honor. This is making a $12,000 credit card case so much more for my client, and Ms. Price, pursuant to the agreement, is responsible for those attorney fees. And I know there's a fine line between allowing a defendant improper or sui juris or whatever the name she's calling it, but this is just abuse of the process, Your Honor. She is alleging things.
The creditor's lawyer speaks directly and without sugarcoating. The judgment is done, the discovery phase is over, and any extra filings could raise more fees that might end up charged to the defendant. His tone sounds firm, but he's warning about something real. Legal procedures are expensive, and losers usually cover the cost.
I believe the opposing counsel has stated he has not received an appeal. I have sent that, all the information you received. He's received that. I have the record, that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract, and lawful consideration, if it's not done, is violation of.
Ms. Price argues this isn't just about a credit card. She wants to see real proof, contracts, consideration, and proper validation. Emotionally, her point makes sense. But in legal terms, an appeal can only use evidence already shown in the trial. If something's missing, you argue the judge made a mistake, not ask for new proof.
All right. Well, here's my where I sit on this one, Ms. Price, is that my position legally here is I can sit as the Court of Appeals to review the judgment in the district court. And what I appear to have in front of me here is a partial appeal, in that I do have the record, at least at what looks like to me, it's not a full record, it's just a transcript of the summary judgment hearing in the district court in Kentwood. Normally, when I get the record from them, it has a whole bunch of other documents that explain, in a nutshell, how that case was reduced to judgment. And I don't have that, so I don't appear to have an entire record. And what I don't have from you specifically is a document called a notice of appeal that tells me that you're appealing a final judgment and that you want me to review that for its legality. I can tell you, because it is on appeal, it follows the appellate rules of the Michigan court rules, and they, for lack of a better term, more intricate and harder to follow than the general court rules or the court rules for proceeding in the district court or in the circuit court. There are a lot more hoops to jump through on appeal, and that's really where you are when you're in front of me. And I can also tell you that on appeal, what I'm supposed to do is look at the record that was generated in front of Judge Sturkenberg, and the new stuff that you file with me, arguments or requests for discovery. Mr. Bequicchio is accurate in saying that normally you don't get any additional discovery on appeal. Normally what you do is you make an argument on what happened below, and that might include that Judge Sturkenberg denied you proper discovery, and that thus she made a legal error that warrants me overturning that case or sending it back to Judge Sturkenberg for work, or things of that nature. And I can
This is the main part of the hearing. The judge clearly explains how the appeal process works. Bring the record from the district court and file a written brief showing exactly where the lower court made mistakes under Michigan law. No new subpoenas, no fresh evidence. Just point out what went wrong and where it's recorded.
Information I would need to decide that. So what I am going to do is direct you to file the requisite notice of appeal and appeal documents within the next 15 days, or I will dismiss the appeal, and you'll have to start that process over again, and the dismissal may have a substantive effect on your ability to file another appeal. So what I'm telling you is this appeal that's in front of me right now is incomplete. It's not documented per the appellate rules, which are found in the Michigan court rules. And, I wouldn't have any choice but to dismiss it unless you supplement it with at least bare minimum a notice of appeal and sufficient information to inform me and Mr. Bequicchio what the nature of your appeal is. It appears that you're appealing from a final judgment. However, all I saw in the final judgment, I think, was the fact that Judge Sturkenberg did grant that on the record. I didn't see. Do you have a judgment in order that you filed, Mr. Bequicchio?
Deadlines are serious. The judge reminds everyone that if the appeal isn't completed correctly, it can be thrown out. That's not harsh, it's how appellate courts keep things fair and organized. It's like submitting all your materials before the referee checks the play. No uploads, no review.
Usually it's assembled by the parties to the appeal. Usually you, as the person, the individual appealing the decision of Judge Sturkenberg, are the one that's going to put that together. Mr. Bequicchio can contribute to that record if he wishes to do so, and then that gets submitted to me, kind of as a here's what happened at the lower court. It tells the story of that in those filings and pleadings filed at the lower court, and then you file a brief on appeal, and your brief makes the arguments as to why Judge Sturkenberg legal errors in her decision making. And, since I'm requesting that brief now, I just thought I was needing the claim of appeal. But since I have a claim of appeal that properly initiates the case on appeal, what I really need then is that record on the lower court. And then I need a brief from you explaining the errors that you think Sturkenberg made. And I'll tell you, I will not be receptive to documents telling me that Judge Sturkenberg or I didn't have jurisdiction. That would be, in effect, saying, Judge, I'm arguing that neither of the courts could really decide this case because of my legal status, sui generis, or, whatever, magic words you're trying to invoke there. That just doesn't work. And the reason it doesn't work, particularly on appeal, is I have to have jurisdiction to decide the appeal in the first place. And if you're telling me I don't have jurisdiction, you're as good as telling me, as judge, dismiss my appeal because, you can't decide it anyway. And so in other words, you got to give me more than that.
Here's an important reminder. If you claim the court has no power over the case, you're basically asking the appellate court to dismiss your own appeal. Fancy phrases won't cancel jurisdiction. What really matters is making clear, logical arguments based on actual Michigan law.
On Michigan law as to what mistakes were made by Judge Sturkenberg in the court below, and then I can decide the matter on appeal. And since I'm looking for the brief on appeal, that's a little harder to put together along with that whole record. I'll extend the time for the filing of the record on appeal and your brief on appeal. I'll give you 60 days from today's date. We're at July the
25th.
25th. Yeah, sorry, my glasses. I'm using a backup pair of glasses because my regular ones are in the shop. So 2 months from today will bring us to September 25th to have those documents filed. And then I'll be able to decide those. And I'll also tell you, Ms. Price, the way it works on appeal is I don't need to grant. You can request oral argument, which would be another version. Today, really, this is more of a status conference. It's not so much oral argument because I couldn't make head or tail of what the file was asking me to do. You can request oral argument if you want it. I don't have to grant it on appeal. Sometimes I just review the record and the filing, decide the appeal based on that. And, of course, Mr. Bequicchio.
As a small act of fairness, the judge grants an extra 60 days and explains that the decision might arrive without another hearing. This extension offers a bit more time, but also adds pressure. The next filing must be clear, well supported, and fully follow the court's rules.
Record to me. I'll leave that to you. as to how much you're going to participate and assist with that production. But you two can talk to each other. The goal being to get everything in front of me that I need to decide the arguments that you make in that brief on appeal, which is where you get a chance to make your substantive argument as to any errors made by Judge Sturkenberg.
Thank you, Your Honor. I will say, to clarify from our position, we did respond to the filing of Ms. Price. With that, we included the complaint, the
Here's the final bit of real advice. Get an official copy of the full lower court record, and if you're unsure, visit the Legal Help Center for proper forms. In the end, it's careful procedure, not attitude, that determines how this appeal turns out.